All right, for those of you that have been missing out all morning long, fear not, you can always go to my Facebook page, and there are a plethora of videos over the last few days that I've put out. How to hold public officials accountable, what to do, how to do, when to do it. And please don't just take my word for these things. Go and research them for yourselves. And put a plan together and then follow through with it. Knowledge without execution is worthless. So, this last couple pages is just a brief recap on the last 2 or 3 videos that I've done. And then we're going to go into some constructive notices and the demand for the production of accounting and documentation. Utilized in a court because, again, they're just hypothecating credit into existence. They're laying a trap or a snare, trying to get somebody to come volunteer and be the debtor, and the correct capacity to come in would be as the creditor, fiduciary, trustee, or the surety seeking your right to be availed, which means you would fill the role of the creditor and take the position for all the rights, titles, and interest derived from the dividends and derivatives from the bonds and securities generated. And then, of course, I've got some other videos that are on my Facebook Live. I don't know how long they'll be left up. Facebook normally doesn't leave them up very long before they take them down. But I show you how to utilize the IRS to get remedy. And remember, remedy, the restoration of your rights, is remedy and property. Rights, property, and remedy. You can't have one without the other. All right? This is a constitutional republic, and what they're subjecting you to is Article 1, Section 8, military tribunal under the War Powers Act, using admiralty and maritime law, and hypothecating your credit into existence without you knowing it, creating controversy using statutes, codes, city ordinances, rules, and regulations that are directly attached to the penal code. On the back side of the penal code, each statute, code, city ordinance, rule, regulation has a penal sum or a penal bond attached to it. That's what's going on. It's all banking. It's all about honor and dishonor. Okay? And so what I'm trying to convey to you, and I hope that you understand it at some point, is to stop arguing. The semantical, nonsensical, babbling horseshit. It's got to come to an end because there are no facts on record. Okay, there are no facts in evidence. There is nothing but hearsay before their military tribunals and maritime admiralty. It's all predicated on presumption and assumption. And you start to argue the facts in the Constitution, those lower courts were created to resolve controversies. Okay, and they're going to tell you that it's criminal, but it's civil. All right, and we can verify that under Code of Federal Regulation, Title 27, CFR 7211, all crimes are commercial. So you have to understand what's going on the back end. And it's better if you don't have an attorney. If you do have an attorney, you better learn what ineffective assistance of counsel is and how to bring claim against them when they try to hoodwink you or screw you because of their either lack of knowledge, or they have knowledge of what I'm speaking of, but they are greedy and like to line their own pockets and want to sell you down the river. Unfortunately, most attorneys and most lower court, low rent judges don't have a clue about what I have been talking about for the last few days on Facebook and TikTok. All right. And although it's not your job to educate, it is your job to document and put forth a valiant effort in remaining in honor. So let's do a short recap, and then we're going to go on to the next document. I think the next document is what we're going to demand, either in the capacity of surety, because the surety, as the surety, the principal is the creditor, okay? Or the alleged creditor. And the surety gets to demand things of the creditor, and if the creditor doesn't perform, the surety is exonerated, okay? Can't be held liable anymore. That's one way of doing it. Then there's the substitution, where you fill the role of the creditor because you come in as surety and you accept the charges for value, all right? And you use your exemption for post-settlement set-off and closure of the account. So, Gene did a couple more things that were interesting. There's a part of the UCC that says to make an endorsement, an endorser liable on an endorsement, the party that holds it must make the presentment. Many times there are staple contracts, like mortgages, in which the terms and conditions are such that you confess judgment and that you waive presentment, etc. For the principal on the instrument, sometimes presentment is not necessary by the terms of the contract. Remember, the contract creates the law and equity follows the law. This doesn't stop you from doing an allonge to the contract and accepting it for value, returning it for the same, all right, ordering them and demanding them to use your exemption for set-off and closure, for full settlement and closure of the account. All those accounts belong to you. For the principal on the instrument, sometimes presentment is not necessary by the terms of the contract. Assume you're going through a mortgage foreclosure in a judicial state. They charge the straw man, okay, the ens legis entity, the United States citizen, the all caps entity, which is the debtor, who was the maker of the mortgage note in the judicial proceedings, and they tend to do a dress service of the complaint upon the straw man, which is done for an illusion and an ulterior reason. Since the straw man has already waived presentment and notice and has confessed judgment, theoretically the banks could come in and have the sheriff seize the asset of the straw man for the liability. In fact, if they serve the straw man and nobody ever shows up to the court to defend that by reason of the rules of the procedure of their admiralty proceedings, the failure to appear becomes a dishonor. Confess the judgment a second time, first on the contract, second on the failure to show up to court. So you have a double witness of confessed judgment, at which time the sheriff can advertise, appraise, and sell the property. The court can seize the property and put the new purchaser in position, all without having to hear boo from you. And you, the living soul, don't have to show up in the court. What happens if you don't show up in the court and they take judgment against the asset of the straw man, and then they do not have the sufficient collateral to seize or levy to pay the debt? Do they have personam jurisdiction against the living soul? The answer to that question is no. You weren't named on the complaint and you didn't show up. So what they are doing is completing the action in rem, not in personam. And because they are completing the action in rem, they are limited to acquiring the value of whatever they get off the seizure, levy, and sale of the goods of the straw man. If you show up in the court and you start to argue as a living man, what have you done? You have become an accommodation party. and appeared in personam. And without paying the debt, you are in dishonor. And now you can be held personally for the liability of the account. The reason they go to court is because when we go back to make an endorsement liable on a note, they must do presentment. Isn't the living soul signed on the instrument? But he is not the principal. He's not the straw man unless he wants to be. So don't they have to do a presentment, service of process, as though it's coming onto him, so he has knowledge that they are presenting it to a living soul to become liable as the accommodation party, because he's not the principal. He may back the principal, the straw man, but he's not the principal. They need him to come in so they can do a presentment against him, but they don't have to do a presentment against the straw man. The reason, let me scroll up here. The reason the court case is there is to give notice to the living soul so that the living soul will come in and act as the accommodation party, to which he's now been told he's been presented. You have been given notice and you are an accommodation party and you now have a liability. So they drug him in personam. They had to do that because he could never waive his rights. If he waived his rights, wouldn't it be a constitutional violation? But there's no constitution for the strawman who waived his rights by the statute stable contract. The statute staple contract. So they'll go against the asset that are registered to the straw man, and that's not a violation of the Constitution. But if they come against the living soul and try to make you liable to pay the obligation of the straw man, they've got to give you notice and opportunity, because you are merely an accommodation party for the straw man. They invite you in and you fall into the trap and become the debtor instead of a creditor. Gene was saying, you have to make the bid. They are looking for money. The problem is there isn't any money in the public, because the public hasn't declared what money is. So the only place they can get the money is from the private side. Can they tell the private side what they can or cannot use as money? No. They cannot tell real people what to do. They are all fiction. They are a fiction, and they can only tell fictions what to do, so that they can come to you, a real person, and solicit you. And if you want to act as though you know what money is and give it to them, they'll take it every day. But they haven't got any over there. They haven't defined money in the fiction. If they are going to use anything as money, which they haven't defined what it is, it can't originate on the public side, because there isn't anything to find. For them to use and circulate in commerce things they are going to use as or call money, it's got to come from the private side. It's got to come from the living people. And since it comes from you, is there a reason why you can't underwrite the bid, the surety, and the payment? Since all it comes from the private side anyway, so why do you allow them to use your signature so that you can become liable for whatever it is that they are circulating as a credit on the public side, and they are taking advantage of all of that because you were ignorant enough to provide what it is that you have got that creates it that they don't have? Are you going to allow the bid money and then allow them to base their activities on your credit to issue corporate surety and corporate payment? Why don't you also issue surety and payment? Gene's position exactly. All of the patriots are going around for decades and decades yelling, government has stolen our sovereignty. Isn't that what they have been saying? How could a fiction steal your sovereignty? Government can't steal anything out of reality. You have to give it up. So if you have lost your sovereignty, the only way you lost it, it wasn't what government did, not what they charged you with. It's not the laws they wrote. It's not the fact that they have all the guns and wear all the badges. Not the fact that they have a president and a court system. You lost your sovereignty when you gave up your commercial capacity by being ignorant. Government is not evil. They may be very deceptive, but they drew the sovereignty out of you because you are too ignorant to be sovereign, because you don't know what a sovereign is and what a sovereign does. And because they drew out from you what you don't even understand, what you've got, you blame them for stealing your sovereignty, and you don't know how they got it away from you. They have become in place of the sovereign because we are collectively ignorant of what sovereign is, and we allow them to drain our sovereignty away by being ignorant. That's not anything they beat out of you or forced out of you, except through your ignorance. You are the principal for the bid, the living man, not the straw man. You can also be the reassurer to guarantee the bid. And by use of your exemption, you are the underwriter on this whole procedure. You just have to understand what's going on, who you are. Understand who they are, the procedure for getting the remedy. They have taken nothing away from you that you have not yourself surrendered. Do you understand the procedure for getting the remedy? There is no money. Everything is and acts like insurance. You have what is called a bank check with a commercial bank whose name is on the top of that check. The bank's name, your straw man, basically has an account in that bank, correct? And you believe that the bank had money, and that if you wrote a check on your straw man account, the bank would pay it. There is no money. Where did your signature and your straw man's name go on the check? Under the bank's name. Did it not? Was your straw man an underwriter of the bank? Let's go back to Gene Keating's 3 sets of bonds: a bid bond, performance bond, and an underwriter. Where does the payment finally come from on those 3 bonds? The underwriter. Whose name / signature is on the bottom of the instrument? The living man's signature. He is the underwriter on the instrument. Did the bank have any money? No. Never did. Never will. Who's responsible for producing the money? The underwriter. The guy that signed the check. Does that prove to you that as a living soul, you have the capacity to put out the third final bond if you understand who you are and what you are doing? You are the underwriter, guaranteeing payment on the instrument. That is not a check to produce money. It's an insurance policy. And you are underwriting, and you are the underwriter, hoping against hope that money will somehow exist to make the payment on the instrument that you signed. Under the new Banking Act that is taking effect very shortly, what is the new procedure with banks as far as checks are concerned? You will not get the original check back once it's processed through the insurance scheme. You will get a photocopy. It's a promise to pay. It's a security that they are going to hold on to, making me liable. They are going to bundle them together, and even as you are the private underwriter, they are sending these canceled checks to public underwriters and offer them as securities to build the great Babylon society on your promise to pay. Why would they send them back? Do you think anybody paid them? There's no money to pay them with. It's an insurance policy. They are keeping as a holder the evidence of the policy that you are writing. You are part of a giant insurance scheme. Does that prove to you all patriots? Does that prove to all you patriots out there that there is no common law? Nothing gets paid. It's all insurance policies. There's no money. It's all admiralty process. You believe we are under the law, and can pay our debts, and the government's doing something wrong. You are in Looney Tune land. You will never get remedy with your stinking thinking. You have got to understand who it is you are. Now, as Gene stated, your exemption only belongs to the living people, and it is deemed intellectual property. And intellectual property is personal property. There are personal property and real property. Real property is immovable property, and personal property is portable. And your intellectual property, your exemption, is personal property. Which means it can leave you in chunks and go. Hold on, I gotta kill this fucking fly. This motherfucker's pissing me off. These things are all supposed to be frozen already. You son of a bitch. Motherfucker. Alright, problem solved. Alright. It's personal property, which means it can leave you in chunks and go to other people as you surrender it. So, as you surrender your exemption to the public, they use it. An exemption can be a commercial lien, and you can resell your lien to other parties. A lien is nothing more than a bill of exchange. Once you have given your signature and offered your exemption, the party receiving your signature can put your signature on collateral derivative documents and reuse it over and over again. Your exemption is the intellectual, the personal property, the foundation of being able to move charges from one credit side of the ledger to the debit side of the ledger. The credit side of the ledger is the public side, and all credit are defined to be liabilities. That's why when you receive a check, it's a liability, evidence of a debt, a promise to pay. There's no asset there. It's a future contract. It's an insurance policy floating around. The debit side of the account is the assets. It's on the private side. You cannot move and post things from the credit to the debit side. They are apples and oranges, and they do not mix. Your bill of exchange goes to the debit side. It's an asset. And in order for them to do a corresponding accounting settlement on the credit side requires a warrant. This little son of a bitch, there's another one. Requires a warrant or an order on the public side. If the exemption is used voluntarily, you can move the charge from the credit to the debit, settling and closing the account. The U.S. is basically foreign to us. When Gene started getting into some of the remedies in this seminar, he was talking exactly about what we have been saying, that when we get the stipulation in terms of the offer, the charge, and we have done an acceptance for value consideration, and we have done a return for post-settlement and closure, and the other side does not issue the order or the warrant to post the compensation and consideration to the public side of the account, we do the certificate of protest and the notice of protest, and have that served properly upon the other party who is in dishonor. Then, what is the remedy? Gene suggests we should look at to Title 10 of the United States Code. Multitasking here. Gene suggests that we look to Title 10 of the United States Code, Section 4801, Uniform Foreign Judgment Act, because your certificate of protest and notice of protest is a foreign default. It's entirely possible that the remedies might exist through the Title 10 Section 4801 and Title 10 CFR, Code of Federal Regulations, and the regulations promulgated thereto to bring to the U.S. District Court possible notice and registration of this form. Remember, particularly in criminal cases, all the state traffic and all other judgments are being bought up as bid bonds by the U.S. District Court, and those bid bonds, when they are not paid by way of your exemption, then the defendant is in default, and based on the default, the bid bond goes out publicly to a whole list of hundreds of corporations all across the U.S. and internationally, and these people purchase the bid bonds. Why would these corporations like Walmart, U.S. Post Office, everyone want to purchase these bid bonds? To make money. What is the purpose of the corporation assuming these bonds? Collateral to invest and expand their business. Hasn't a friend in the Minnesota, Wisconsin been telling us for a long time that the whole system is operating on municipal bonds? Isn't a municipality nothing more than this private U.S. corporation? Aren't the U.S. district courts providing the fundamental bid bonds as the foundation to create money, i.e., this money is credit money? What is credit? Liability. And isn't this sale of the municipal bonds, which goes down to Payne Weber, which acquires these securities by underwriting half of thousands of U.S. corporations to fund their business expansions? How are the corporations doing business? They are doing business by acquiring the investment securities at low-cost levels, which are then being insured by the performance insurance companies, indemnifying them against the loss on collection, which then goes to the securities underwriters to raise the funds in the public marketplace. The municipal bonds for the securities underwriters, for the municipal bonds for funding and approval for all these projects gets approved to finance the wonderful world of Babylon. When someone asked Gene, how do you get someone out of jail? One of the things he said was, first, if you're going to get yourself out of jail, you are going to have to do the registration on the UCC to separate you from the straw man so that you have the capacity to act as the creditor intervener. Eventually, you'll have to go online in the court system, and you're going to have to find out which corporation purchased your bid bond through the U.S. District Court. Then you are going to have to do an acceptance for value and consideration and return, ask for post-settlement and closure for the use of your exemption. That will start you on that process. This is the end of part 2. So I hope that helps you out a little bit. What is it exactly we're going to be doing next? Let's see here. I told you I'd show you guys the equitable side of the statute for the GSA bonds. For other members, I observed that once you have returned to competency, there's nothing they can do that we can't do. All of the authority granted to the public trust comes from we the people, and the people cannot delegate authority they do not have. Secondly, like the income tax, only you that can assess the GSA forms. From Form 28 and the initial portion of the 91 and 90 forms provide an opportunity to establish the record of the birth bond, identifying by the BC number as surety for the contract represented by the Social Security number. So, when you list the straw man as the warranted contracting officer further down on the 9091, which is a release of lien and release of surety and release of assets, it is already conceded to have a warranty in the form of the birth bond estate, confessed in the first paragraph. As a subsidiary of the United States Federal Corporation under Title 28, 3002, 15A, B, and C, it is, in fact, the only officer on the contract. The forms are handing a remedy on a silver platter to those who will look. Instead of reading GSA website, you might give a look to Section 28 CFR and 53 of through 53 of CFR, 48 CFR. So 48 CFR, you're going to be looking at sections 28 through 53. Third, when the county received the birth bond, it issued a certificate of birth. That's the receipt that proves the delivery, similar to a bill of lading. It is also security under Title 15 in that it is a certificate of interest. What many people fail to realize is that the failure to return equity when the county registrar received it comprises a stipulation to the creation of a resulting trust. By definition, they are the trustee on the trust. They are holding the instrument. They are holding all the equity. That means that they, all of the public officials in total, not you, are obligated to perform as trustees on the bond according to the rules of the public trust. Namely, all of the statutes, codes, and regulations that you are so convinced apply to you. So once you declare the trust, everything you believe goes out the window and is replaced by the original reality that they are the trustees and you are the beneficiary benefactor, or sestaquiwi. Fourth, they never gave you equity, so they have no standing to demand equity on any statute. On the other hand, you have every right to demand satisfaction. In fact, not only are you not restricted from using the 9091 form, you are the only one with the authority to release the lien against the real property, your body, and release the personal property, the bonds, that they concocted in your name and against your credit. Who else has the Father empowered to nourish your body until he returns to claim it? The reality is that they have got you digging through statutes looking for reasons you can't claim your securities and your own body, when the simple truth is that Scripture tells us exactly who enjoys the exclusive divine right, and that's you. Statutes and double entry accrual bookkeeping are Lucifer's tools to entice your consent. As to me being a GSA employee, all our strawmen are U.S. employees by definition, or they would not be subject to Title 26. However, permit me to caution that you are free to comment as you see fit, but this group has a two-strike policy regarding condescension and attacks on people's intentions. We leave that sort of venom to the politicians and professional agitators who seek to covet it. We will not be adding to the decline of discourse in society in contravention of Scripture. Thank you for your understanding, Bill. Now, what I wanted to point out and what I said I was going to point out, because I'm not going to read all this to you. This is 43 pages long. And like I said earlier, where you can find it is in Title 48, Code of Federal Regulations. It's going to be sections 28 through 53. But what I want to show to you is the equitable right of redemption of a surety that is statutorily provided. And when I read it, I was like, oh, this is brilliant. This is so brilliant. This tells you how to fill out the SF-24, SF-25, SF-25A, 273, 274, and 275. Okay? See here, 28.102, performance and payment bond and alternative payment protection for construction contractors. Talks about the Miller Act. All right? Tells you exactly how to do it. What I want to find is very specific. Contract clause. Tells you what has to be in there in the contract clause. Performance and payment bonds for other than construction contracts. Okay? Where is this contract clause, payment bonds? Give me a second. Here we go. Administration. What are they doing in maritime admiralty law? They're administering under the executive branch. They're ministerial administrators administering a bankruptcy. So 28.106, administration, bonds and bond-related forms. The following standard forms, SF, and optional forms, OF, shown in 53.301 and 53.302 shall be used except in foreign countries when a bid bond, performance bond, or payment bond, or an individual surety is required. The bond form shall be used as indicated in the instruction portion of each form. They're telling you exactly where you're going to find the instructions. Here they are. SF24, SF25, SF25A, SF25B, SF28, Affidavit of Individual Surety, SF34, SF35, SF273, SF274, SF275, SF414, SF415, SF416. Okay? All right, and then you got the OF90 and the OF91. Release a lien on real property and the release of personal property from escrow. All right? So where are you going to find that? Code of Federal Regulations, Title 48 CFR 28.106. All right, in the administration, 28.106. All right, this is exactly what they're doing in the state courts. They're doing it in the lower state district courts. They're doing it in the municipal courts, the city courts. Okay, that's what they're using. Now, let's get to the equitable side of this. I got to find it. Contract clause, additional securities. Oh, I got an important call. I got to make that call. Hold on. I'm not leaving until I share this with you. Consent of the surety. When any contract is modified, the contracting officer shall obtain the consent of the surety. Where else do we see that? Title 15, 1692C. Title 15, 1692C. When in communication with the consumer, you must have consent to communicate with the consumer. Prior consent of the consumer to communicate with them. All right? This is the equity within this. Furnishing information. Here it is. Surety. Here's the equity I was talking about in Henry R. Gibson Suits and Chancery. Remember I told you operating in the capacity of the surety, how much fucking power you have? All right. The surety on the bond upon a written request may be furnished information on the progress of the work, payments, and the estimated percentages of completion concerning the contract for which the bond was furnished. Now, if you go in there as a debtor and you say, I want a full accounting, guess what? They're not going to do anything for you because the principal creditor has no obligation to answer to what is the presumption and assumption that you're the debtor. Okay? But if you come in as surety under 48 CFR 28.106-6, furnishing information, it's telling you that when the surety commands the principal creditor to produce under UCC 9-210 a full accounting, right? Okay? Or any other documents that pertain to the bonds or any other information, right? That they have to do it. Let's see what they say. When a payment bond has been provided, the contracting officer shall, upon request, furnish the name and address of the surety or sureties to any subcontractor or supplier who has furnished or been requested to furnish labor or materials for a contract. In addition, general information concerning the work progress, payment, and estimated percentage of completion may be furnished to persons who have provided a labor or materials and have not been paid. You as a surety have not been paid. You're coming into the role of the creditor. You're substituting yourself as surety in the role of the creditor, assuming the rights, titles, and interests the creditor is entitled to because you have a right to be availed. Okay? How do we get availed? How do we know what's in the accounting? All right? We're going to get to that in a minute. But you have to first understand the capacity of surety. All right? And this goes directly back to Henry R. Gibson's Suits and Chancery, suretyship, subrogation, substitution, and exoneration. All right? This is the equity within the statutes. When a payment bond has been provided for a contract, the head of the agency or designee shall furnish a certified copy of the bond and the contract for which it was given to any person who makes a request. Therefore, and who furnishes an affidavit that the requester has supplied labor or materials for such work and payment therefore has not been made, and or that the requester is being sued on such bond. The person who makes the request shall be required to pay such cost of preparation as determined by the head of the agency or designee to be reasonable and appropriate. See 40 U.S.C. 3133. Okay, so in other words, when you come in the capacity of surety, demanding a full accounting and all the paperwork and everything that goes with it, so you're wanting the QSIP number, the auto trice number, you're wanting the bond numbers and all that good stuff, all right? And we're going to get into exactly what you want, because I understand you don't get it yet, but I'm going to make sure you do by the end of this. But I want you to understand the importance of capacity, and when you're writing, how you're writing to them, and what capacity you're writing to them in. All right, you haven't been paid for your services. You haven't been paid for your precious value time commodity. Remember, the all caps ens legis person is the United States citizen, is a debtor, okay? And you're coming in as surety to take care of this debt and to move the liabilities to the asset side of the ledger so you can debit it and use the funds, the fungible funds. D, Section 806A2 of Public Law 102 through 190, as amended by Section 2091 and 8105 of Public Law 103-355, requires that the federal government provide information to subcontractors on payment bonds under contracts for other than commercial items as defined in subpart 2.1 upon a written or oral request of a subcontractor. I always recommend doing the written one. Then you can default them. All right, they're liable. They carry a primary active degree of fault because they may cause the surety harm by failing to perform and give you the proper information that you need so you can properly fill out the performance bond, bid bond, payment bond, and the GSA 273, 274, and 275. All right? Or oral request of a subcontractor supplier or prospective subcontractor supplier under a contract with respect to which a payment bond has been furnished pursuant to the Miller Act. The contracting officer shall promptly provide to the requester, either orally or in written or in writing as appropriate, any of the following. Now look, pay attention. 1, name and address of the surety or sureties on the payment bond. Penal amount of the payment bond. That's exactly what we're looking for. Copy of the payment bond. The contracting officer may impose reasonable fees to cover the cost of copying and providing a copy of the payment bond. We don't have a problem. What is that going to be? A total of $6.30? Who gives a flying rat's ass, right? Okay? So this is what we're looking for right here. And this is where I'm telling you that statutorily I can see the equity here and the furnishing of the information so long as you're coming in as the surety. Okay? This is what they're talking about, the withholding of the payment. The penal amount of the bond should not exceed the surety's underwriting limit stated in the Department of the Treasury circular. All right? So anyway, you guys can go read this for yourselves. I got to make an important phone call. This is going to be a short video, unfortunately, for you guys. Anyway, now you know where to find it. Okay? 48 CFR sections 28 through 53. Okay? And I just wanted to show you that equitable right of redress and restoration being found statutorily. Okay? Consent of the surety means an acknowledgement by a surety that its bond given in connection with a contract continues to apply to the contract as modified. Penal sum. Penal amount means the amount of money specified in a bond or a percentage of the bid price in a bid bond as the maximum payment for which the surety is obligated, or the amount of security required to be pledged to the government in lieu of a corporate or individual surety for the bond. Okay, what are you going to use in order to come in as surety? you're going to extend your exemption. Your exemption is going to go ahead for post-settlement and closure. And that gives you the right to come in as surety and demand the full accounting. Reinsurance means a transaction which provided that a surety for a consideration. Remember, everything's about value, consideration, and performance. Agrees to indemnify another surety against loss which the latter may sustain under a bond which it has issued. Okay, that's why when you do the SF 24, 25, and 25A, you also have to issue the reinsurance for the federal government to make sure they don't sustain a loss. So you have to issue the SF 274, 275, and 273. All right? Boom. So, anyway, you guys have a little bit of a reading assignment. And don't feel bad when you read this and you don't quite comprehend it. Go back and rewatch some of these videos. Okay, name of the person contracted, date and time of the contract, response of the surety. All right? If the surety declares the power of attorney to have been invalid, the contracting officer shall not allow the bidder to substitute a replacement power of attorney or the replacement surety. Determination for non-responsibility based on unacceptability of the power of attorney are not subject to the certificate of competency process of subpart 19.6 if the surety has disavowed the validity, of the power of attorney. Okay, I already told you where your power of attorney is. You can find that in the Lieber Code, Executive Order 100, Article 2, Article 31, and Article 38. Article 38 more specifically. You can also find that in 40 Statute at Large 112, 40 Statute at Large 411, Section 7E. If you read that one paragraph, 40 Statute at Large 411, Section 7E, you will quickly realize that your birth certificate is, in fact, the certificate that they're talking about, and that is evidence that you are, in fact, the attorney, in fact, having power of attorney. But you got to go read it to understand it, to comprehend it, all right? These people have authenticated your credit into existence without your express written consent or permission, all right? And you're due in owing all the profits and proceeds that they generated. All right? Don't abandon your claim. In here it talks about the irrevocable letter of credit. That's beautiful. The irrevocable letter of credit is phenomenal. Here's another problem that everybody makes. They freely give their over-the-counter securities and they don't make them a special deposit and get a deposit slip or a certificate of deposit. So you're gifting it to them under the Class 5 gift and estate tax. It's a gift, unless you declare it otherwise. All right? So get your certificate of deposit. The contractor's deposit certificate of deposit from a federally insured financial institution, FDIC, right? With the contracting officer in an acceptable form, executable by the contracting officer. All right? Your all caps ens legis entity is the contracting officer, ladies and gentlemen. You are not the thing. You are not the in rem thing. So, anyway, I got to make this call. It's an important one. I love you guys. I hope this helps out a lot. A deposit of the types of sureties listed in 28.204-1 and 28.204.2. The contractor shall submit to the government one of the payment protections selected by the contracting officer. All right? The contractor shall furnish all bonds or alternative payment protections, including any necessary reassurance agreements. It tells you, as you read all this stuff, it tells you exactly what you need to do. Point by point by point. It's a paint by numbers fucking board game. That's all it is. All right? And again, we want to go down here. You're looking at the performance bond, the payment bond. And this section particularly is for the construction, right? And the contracts. Securing additional payment protection. Reducing the amount. Contract clause right here. 28.102-3. This is what has to be there. insert a clause substantially the same as the clause at 52.228-15. So you got to go to 52.228-15. And you're going to go grab that clause. They're telling you you must insert the clause. They're telling you how to fucking do it, for fuck's sake. Performance and payment bond construction. In solicitation and contracts for construction that contain a requirement for performance and payment bonds if the resultant contract is expected to exceed $150,000. Okay? We don't know what that contract is yet. We need to tell them, hey, we're accepting the charges for value. Please use our exemption account for post-settlement enclosure. In the interim of time, since we're coming in as surety to satisfy the debt that you guys created, the liability on your end, we need you to perform. We're giving the value in consideration. We need you to perform. We need a full accounting. We need everything that you've completed so far. We need how much funds, because remember, when they create the charges, they get the check instantaneously. All right? So again, it's going to tell you, you know, if those numbers exceed 150,000, you know that you have to go to 52.228-15 for the performance payment bond and insert the clause that needs to be there. All right? Performance bond, contract clause. Again, in each one of these, there's always a contract clause. If you fuck up and don't put the contract clause in there, your documentation will fail. The contracting officer shall insert a clause substantially the same as the clause at 52.228-16. They're telling you exactly where to go find that clause. 52.228-16. 52, where's it at? This is lien or release real estate. 52.228. I'm pretty sure that I have it here. I might not have it here. I know I have it here. It's in 40 pages. 52.228-16. Holy molies. All right, here's 5. 5.3. We need 5.2. 5.3. Where's 5.2? 5.3.222. It's a lot to read, but once you get this done, look. 53.204 Administrative Matters. Safeguarding classified information within industry, DD Form 254, DD Form 441. Contracting qualifications, all right? Remember, they have a duty to publish it. They don't have to tell you where to find it, all right? Standard forms. We're almost there. Oh. Damn it, it goes back up to 28.331. So in order to find that, you need to go find 52.2289. Or 16, excuse me, to go find the contract clause that needs to be in the SF 24, 25, and 25A. And the 273, 274, and 275. It's your duty to put it there. Unfortunately, I don't have it on this page. It only goes to the 5.3s. Overprinting, computer generation, standard form, special construction, and printing. Anyway, I got to make this call. I love you guys. I'll be back on later to go through this a little bit more. Hey, right here. Lien on real estate. We agree that this instrument constitutes a lien in the amount of the dollar amount on the property described in this lien. The rights of the United States government shall take precedence over any subsequent lien or encumbrances until the lien is formally released by the duly authorized representative of the United States. We hereby grant the United States the power of sale of subject property, including the right to satisfy its reasonable administrative costs, including legal fees associated with any sale of subject property in the event of contractor default if we otherwise fail to satisfy the underlying bid, guarantee, performance bond, or payment bond obligation as an individual surety on solicitation contract number. The lien is upon the real estate now owned by me, us, described as follows: legal description, street address, and other identifying property. In witness hereof, we hereunto affix our hand and seal this day of, and then of course you got your notary presentment and statement, right? Commission expires. So all kinds of goodies. Anyway, I'll talk to you guys shortly.